Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In the previous two lectures, we explored external risk mitigation, first through third-party non-disclosure agreements that govern vendor and partner relationships, and then through supply chain management and cybersecurity due diligence. We learned that external disclosures are both necessary and dangerous. You must share secrets to do business, but sharing creates vulnerability. Now, in this final lecture of Module 5, we turn to the highest stakes external disclosure scenario: mergers, acquisitions, and venture capital due diligence. These are the transactions where companies must reveal their most valuable secrets, not to operational partners or vendors, but to potential buyers, investors, or strategic acquirers who are deciding whether to write checks worth millions or billions of dollars. The paradox here is acute. Investors and acquirers demand transparency. They want to see your technology, your customer relationships, your financials, your strategic plans, everything that makes your business valuable. But the moment you disclose that information, you lose control. If the deal falls through, the other party walks away with knowledge they didn't pay for. If they're a competitor, they might use that knowledge against you. If they're a strategic buyer with parallel development projects, the information you shared might contaminate their own work, or yours. This lecture addresses how to resolve that paradox through staged disclosure, a framework for revealing information incrementally, matching the level of disclosure to the level of commitment, and building protections that survive even if the transaction fails. We'll explore the 5 phases of disclosure, from teaser documents that share almost nothing to final due diligence where everything is revealed. We'll examine the technical and legal tools that make staged disclosure work: virtual data rooms, clean team protocols, standstill provisions, and deal protection clauses. And we'll close with the moment of maximum vulnerability: post-deal integration, when two organizations merge and secrets that were once separate must now coexist. By the end, you'll understand that M&A and venture capital due diligence aren't just about showing your cards. They're about revealing them one at a time, under controlled conditions, with mechanisms in place to limit damage if the deal collapses. Let's start with the framework itself. The 5 phases of staged disclosure. Staged disclosure is built on a simple principle. The more committed the other party is, the more they get to see. Early in the process, when interest is exploratory and non-binding, disclosure is minimal. As the relationship deepens, through signed non-disclosure agreements, exclusivity agreements, letters of intent, access expands. By the time a definitive purchase agreement is signed, the buyer or investor has seen nearly everything. This structure protects the seller or company seeking investment by ensuring that sensitive information isn't shared with parties who might walk away, shop the deal, or use the information competitively. Phase 1, the teaser. This is the initial marketing document, often just a few pages, that describes the opportunity in broad terms without revealing trade secrets. A teaser might say, SaaS company in the healthcare vertical, $10 million annual rate of return, 40% year-over-year growth, proprietary, artificial intelligence-driven analytics platform. It doesn't name the company, doesn't describe the technology, and doesn't disclose customers. The teaser's purpose is to gauge interest. If a potential buyer or investor isn't interested at this level, there's no reason to share more. The teaser is typically distributed without an NDA because it contains no confidential information. Phase 2, the Confidential Information Memorandum, or CIM. Once a party signs an NDA and expresses serious interest, they receive the CIM, a more detailed document that includes financials, market positioning, competitive landscape, and high-level descriptions of the business model. The CIM might reveal the company's name, its major customers, in aggregate, and general descriptions of products or services. But it still doesn't disclose trade secrets. It doesn't include source code, proprietary formulas, detailed customer contracts, or technical specifications. The CIM is designed to help the buyer or investor decide whether to proceed to the next stage: a management presentation or site visit. Phase 3, management presentations and limited Q&A. At this stage, the buyer or investor meets with the company's leadership team tours facilities, and asks questions. Disclosure becomes more granular. The company might explain how its technology works, what makes it differentiated, and how it plans to scale. Even here, however, trade secrets are described, not shared. The company might say, "Our algorithm uses a proprietary clustering method that reduces processing time by 60%, but it won't hand over the source code or the mathematical model." The goal is to demonstrate value without giving away the keys. This phase often includes an enhanced NDA with stricter terms, prohibition on reverse engineering, limits on who within the buyer's organization can receive information, and explicit statements that no license or right to use the information is granted. Phase 4. The data room. If the buyer or investor decides to move forward, often signaled by a letter of intent or LOI or term sheet, they gain access to a virtual data room or VDR, a secure online repository containing detailed documents, contracts, technical specifications, and proprietary materials. This is where trade secrets are actually disclosed. The data room might include customer contracts with names and terms, source code repositories, patent applications not yet published, manufacturing processes, R&D roadmaps, and employee compensation data. Access to the data room is tightly controlled. Only named individuals can log in. Documents are watermarked with the viewer's name and timestamp. Some files are view-only, no download, no print. Access is logged, who viewed what, when, and for how long. And the data room is organized in tiers so that the most sensitive materials require additional approval to access. Phase 5. Final due diligence and definitive agreement. In the final phase, after a term sheet is signed and the deal structure is agreed upon, the buyer or investor conducts comprehensive due diligence. This might include technical audits, interviews with key personnel, site visits to facilities, and review of every material contract. At this stage, the transaction agreement itself, whether a stock purchase agreement, asset purchase agreement, or investment agreement, includes indemnities, representations, and warranties, and escrow provisions that allocate risk if something goes wrong. The agreement may also include non-circumvention clauses that prohibit the buyer from using disclosed information to compete if the deal fails, and breakup fees that compensate the seller if the buyer walks away. These 5 phases create a funnel. Many parties enter at Phase 1. Fewer reach Phase 2. Only serious buyers or investors make it to Phases 4 and 5. And only one, ideally, closes the deal. Let's dive deeper into the data room, because this is where trade secrets are most exposed. A virtual data room is a cloud-based platform designed specifically for secure document sharing and high-stakes transactions. Unlike Dropbox or Google Drive, which are built for collaboration, virtual data rooms are built for control. They assume that the people accessing the documents might be adversaries, and they design accordingly. Access controls are granular. The seller can specify exactly who from the buyer's team can see which documents. A buyer's CEO might have access to financials and customer contracts, but not to source code. A buyer's technical team might see engineering documents, but not compensation data. This segmentation limits exposure if one person on the buyer's team acts improperly. Watermarking is standard. Every document viewed in the data room is overlaid with the viewer's name, the date and time, and a unique identifier. If a document leaks, the seller can trace it back to the person who accessed it. This doesn't prevent leaks, but it creates accountability and serves as evidence in litigation. View-only restrictions prevent downloading or printing of sensitive files. The buyer can read the document on screen, but they can't save a copy, email it, or take a screenshot. At least not easily. Sophisticated users can bypass screenshot restrictions, but the barrier raises the cost of misappropriation. Time-limited access ensures that once the deal closes or collapses, the buyer's access expires automatically. The seller doesn't have to rely on the buyer returning or destroying documents. The platform simply revokes permissions. Activity logs create a detailed audit trail. The seller can see exactly what the buyer's team looked at, how long they spent on each document, and whether they attempted to download or print. These logs serve 2 purposes. First, they help the seller assess the buyer's seriousness. If they're spending hours in the technical specifications, they're doing real diligence. Second, they provide evidence if the seller later suspects misappropriation. But virtual data rooms aren't perfect. They can't prevent someone from taking photos of their screen with a phone, or from memorizing key details, or from dictating information into a recording device. And they don't address the deeper problem. Once information is disclosed, it can't be undisclosed. That's where clean team protocols come in. A clean team is a small group of individuals, usually external advisors, like investment bankers, accountants, or lawyers, who are allowed to see highly sensitive trade secrets during due diligence, but who are contractually prohibited from sharing what they learn with the buyer's operational teams until the deal closes. The purpose of a clean team is to prevent contamination. If the buyer's engineers see the seller's source code before the deal closes, and the deal then falls apart, those engineers now carry knowledge of the seller's technology. Even if they don't intentionally copy it, that knowledge might influence their future work. Courts sometimes call this inevitable disclosure, the idea that once someone knows a secret, they can't help but use it. Clean teams solve this problem by creating a firewall. The clean team reviews sensitive materials, assesses risks, and reports back to the buyer's decision makers, but only in summary form. They might say, the technology is proprietary and defensible, but there are integration challenges. They don't explain how the technology works or what the integration challenges are in detail. Here's how it works in practice. The seller designates certain materials, source code, manufacturing processes, customer pricing models, as clean team only. Those materials are stored in a separate section of the data room, accessible only to named individuals who have signed a clean team agreement. That agreement includes several key provisions. No operational integration until closing. Clean team members can't participate in integration planning, strategic discussions, or product development. No disclosure to business teams. Clean team members can provide high-level assessments, but they can't share specifics. Continuing confidentiality obligations even if the deal fails. If the transaction collapses, clean team members remain bound not to disclose or use what they learned. Liquidated damages or injunctive relief if the clean team agreement is breached. Clean teams are especially important when the buyer is a competitor. In those situations, the risk of contamination is highest. If a competing company's product development team sees your roadmap, your feature set, or your technical architecture, they might, consciously or unconsciously, adjust their own strategy. Clean teams prevent that by ensuring that only independent advisors see the details. Courts recognize clean team protocols as evidence of reasonable efforts to maintain secrecy. In Pivotal Software versus Tibco Software, a 2016 case, Pivotal alleged that Tibco had misappropriated trade secrets after a failed acquisition attempt. Pivotal argued that Tibco's engineers had seen proprietary information during due diligence and then incorporated it into Tibco's own products. The court allowed the case to proceed in part because Pivotal could show that it had used a data room with access controls. But the case also illustrated the limits of those controls. Once information is disclosed, even under restricted conditions, the risk of misuse remains. The lesson: clean teams reduce risk, but they don't eliminate it. If the buyer is a direct competitor, the seller should consider whether to disclose crown jewel secrets at all, or whether to condition such disclosure on a signed definitive agreement with substantial breakup fees. Staged disclosure and clean teams are operational controls, but legal protections matter too, especially deal protection clauses that constrain the buyer's behavior and compensate the seller if things go wrong. Standstill provisions prohibit the buyer from using information disclosed during due diligence to make a hostile bid, poach employees, solicit customers, or compete with the seller. A standstill typically says, for X months after termination of this transaction, buyer shall not, directly or indirectly, solicit the company's employees, customers, or suppliers, or use any confidential information disclosed during due diligence for any purpose other than evaluating this transaction. Standstills are especially important when the buyer is a competitor or strategic player in the same market. Without a standstill, the buyer could enter due diligence, learn everything about the seller's business, walk away from the deal, and then use that knowledge to undercut the seller or hire away key personnel. Courts enforce standstill provisions if they're reasonable in scope and duration. A 2-year standstill might be upheld. A 10-year standstill probably wouldn't be. No-shop clauses prevent the seller from soliciting or entertaining competing offers once a letter of intent is signed. The buyer wants assurance that if they invest time and money in due diligence, the seller won't use that process to drive up the price by shopping the deal to other buyers. A typical no-shop says, during the exclusivity period, sellers shall not solicit, initiate, or encourage any inquiries or proposals regarding an acquisition, merger, or investment from any third party. The exclusivity period is usually 60 to 90 days, long enough for the buyer to complete diligence, but not so long that the seller is locked in indefinitely. No-shop clauses are bilateral protections. They benefit the buyer by ensuring focus. They benefit the seller by signaling to the buyer that the seller is serious and not just using the LOI as leverage. Breakup fees, also called termination fees, compensate the seller if the buyer walks away after signing a definitive agreement. The fee might be a flat amount, $5 million for example, or a percentage of the deal value, typically 2% to 4%. Breakup fees serve two purposes. First, they deter buyers from backing out for trivial reasons or using the threat of termination as a negotiating tactic. Second, they compensate the seller for the opportunity cost of taking the business off the market, the expense of due diligence, and the potential damage to relationships with employees, customers, or other stakeholders who learned about the pending sale. But breakup fees are controversial. Buyers argue that they shouldn't have to pay to walk away if diligence reveals problems. Sellers argue that without a breakup fee, buyers can extract information and then abandon the deal with no consequences. The compromise is usually a tiered structure. No fee if the buyer terminates for cause, material misrepresentation, failure to meet closing conditions, but a fee if the buyer terminates for convenience or to pursue a competing transaction. Expense reimbursement provisions are another form of protection. Even if there's no breakup fee, the seller might require the buyer to reimburse legal, accounting, and advisory fees if the deal collapses. This doesn't compensate for lost opportunity, but it prevents the seller from bearing all the transactional costs. Let's assume the deal closes. The buyer has acquired the company, or the investor has funded the round. Now what? This is the moment of maximum vulnerability, because two organizations with separate systems, separate personnel, and separate secrets must now integrate. Employees from the acquiring company need access to the acquired company's systems. Proprietary information that was once siloed must now be shared across teams, and the risk of inadvertent disclosure or deliberate misuse spikes. Post-deal integration raises several trade secret challenges. First, who owns what? If the deal was an asset purchase rather than a stock purchase, the buyer acquired specific assets. But what about know-how, processes, or relationships that weren't explicitly listed? Courts sometimes have to untangle whether certain information was transferred as part of the deal or remained with the seller. Second, how do you prevent leakage? During integration, employees from both sides work together. The acquiring company's engineers might learn the acquired company's methods. If those engineers later leave and join a competitor, did they take trade secrets? Whose trade secrets, the acquirers or the acquired companies? Third, what happens to pre-deal confidentiality obligations? Employees of the acquired company signed non-disclosure agreements with their former employer. Do those non-disclosure agreements still apply after the acquisition? If the acquiring company wants to share the acquired technology with its other subsidiaries, does that violate the original confidentiality terms? The solution is to address these questions explicitly in the transaction agreement. The purchase agreement should specify what information is being transferred and what remains with the seller, if any, what confidentiality obligations survive closing and which are terminated, how integration teams will be structured to minimize exposure of crown jewel secrets to unnecessary personnel. What happens if integration fails and the parties need to unwind the transaction or operate separately? Integration plans should also include ongoing access controls. Just because two companies have merged doesn't mean everyone in the combined organization should see everything. Need-to-know principles still apply. Engineers working on one product line don't need access to a different product line's source code. Marketing teams don't need visibility into technical specifications. Finally, indemnification provisions in the transaction agreement allocate responsibility if trade secrets are misappropriated post-closing. If an employee of the acquired company turns out to have brought confidential information from a former employer, who bears the risk, the buyer or the seller? If a trade secret disclosed during diligence leaks after closing, who is liable? These questions should be answered in the agreement, not litigated later. Not every deal closes. In fact, most don't. Letters of intent fall apart. Due diligence reveals problems. Financing doesn't materialize. The buyer gets cold feet. When a deal fails, the critical question is, what happens to the information that was disclosed? Legally, the NDA and any related agreements remain in effect. The buyer is still obligated not to use or disclose what they learned, but enforcement is difficult. How do you prove that the buyer's subsequent product development was influenced by what they saw in your data room? How do you show that an engineer who reviewed your code during diligence didn't carry that knowledge into their next project? This is where return and destruction obligations become critical. The NDA should require that upon termination of the transaction, the buyer must return or destroy all physical and electronic materials received from the seller. Delete any copies stored in backup systems, cloud environments, or personal devices. Provide written certification, signed by a senior officer, that all materials have been returned or destroyed, and that no copies remain. The certification creates a legal record. If the seller later discovers that the buyer retained information, the certification can be used as evidence of breach and potentially as a basis for sanctions or punitive damages. Some agreements go further and require a post-termination audit. The seller can inspect the buyer's systems within a certain time frame after the deal collapses to verify that information was actually destroyed. This is rare. Buyers resist it as intrusive. But it's sometimes negotiated in high-stakes deals where the risk of contamination is severe. Litigation as a deterrent also plays a role. If a deal fails and the seller suspects misappropriation, they should act quickly. Courts give weight to prompt action. Waiting months or years to file suit weakens the claim because it suggests the seller didn't truly believe the information was critical. In Auto Channel Incorporated versus Speedvision Network, a 2001 case, Auto Channel disclosed proprietary programming concepts during joint venture negotiations. When Speedvision launched a competing network using similar concepts after the deal fell apart, Auto Channel sued. The court dismissed the case because there had been no signed NDA and no evidence that Speedvision had agreed to keep the information confidential. The lesson: hope is not a strategy. If you disclose secrets during deal negotiations, you must have enforceable contractual protections in place. Let's recap. M&A and venture capital. Due diligence create a paradox. You must reveal secrets to create value, but disclosure itself threatens to destroy that value. Staged disclosure resolves this paradox by matching the level of information shared to the level of commitment from the buyer or investor. The 5 phases: teaser, CIM, management presentations, data room, and final diligence ensure that only serious parties see sensitive materials. Virtual data rooms provide technical controls, access restrictions, watermarking, view-only files, time-limited access, and activity logs. But virtual data rooms can't prevent all misuse, especially memorization or indirect use of knowledge. Clean team protocols create legal and operational firewalls, ensuring that only independent advisors see crown jewel secrets and that operational teams don't access information until the deal closes. This prevents contamination and reduces the risk of inevitable disclosure. Deal protection clauses, standstills, no-shops, breakup fees, and expense reimbursement constrain the buyer's behavior and compensate the seller if the deal fails. These provisions are essential when the buyer is a competitor or when the seller is taking the business off the market. Post-deal integration is the moment of maximum vulnerability. Transaction agreements should specify what information is transferred, what confidentiality obligations survive, and how integration teams will be structured to minimize unnecessary exposure. When deals fail, return and destruction obligations, written certifications, and prompt litigation are the seller's primary tools for protecting disclosed secrets. This concludes Module 5. We've covered the full spectrum of external risk mitigation: third-party non-disclosure agreements, vendor and supply chain management with cybersecurity due diligence, and staged disclosure in high-stakes transactions. In the next module, we'll turn to enforcement. What happens when all these protections fail? And you must go to court to defend your trade secrets. Thanks for listening. See you in the next module.